Hi, this is Bruce Pruittham from Pruittham Law and Mediation Services, and this video covers the timeline for a guardianship proceeding and the work of the guardian ad litem in the establishment of the guardianship relative to the person who needs the guardianship, who's referred to as the alleged incapacitated person, or AIP for short. We've put the timeline with the relevant court dates due onto a spreadsheet. So in column B, you see that there's a due date. This is when things should happen, or the deadline that the statute requires. And the statute is RCW 11.88. Some of these have citations to the statute to help you locate specifically the section. And then in C, you have when the event has actually occurred. In this particular spreadsheet, as you fill in these yellow shaded cells in the spreadsheet, other dates will self-calculate based on the number of days that task number 2 or event number 2 is due based on event number 1. For example, if the petition is filed on July 21st, then by 5 court days, which does not include weekends, so essentially 7 calendar days, the due date for the guardian ad litem to be notified and served that they have been appointed would be July 28th. We're going to assume that the guardian ad litem is appointed when the petition is filed, which is typical in King County, and that we will be able to serve the guardian ad litem simply with a phone call and then emailing the documents to the guardian ad litem. So the guardian ad litem will be appointed on the same date. But each of these yellow fields is a date that would be filled in as events actually occur, and then they will set up the additional. In this example, we've filled them in with dates that we predict at this point will occur, just so that you can see the due date as it fills in. So first thing is the petition is filed, the guardian ad litem is appointed, and the guardian ad litem is served. Then the guardian ad litem has some time to make at least a preliminary selection of a medical examiner, somebody who will examine the alleged incapacitated person, or AIP, to advise the guardian ad litem, who is typically a lawyer but does not have to be, but is almost for sure not going to be a physician. That medical examiner can provide information for the guardian ad litem to determine whether the alleged incapacitated person, or AIP, is indeed incapacitated. If so, how much and in what ways? And in what ways relative to their financial interests, and in what ways relative to their personal care. So a guardianship may be full for both the estate or financial matters, and also as to the person, meaning care of their body, or partial, or determined that it's not necessary as to the body, but it is necessary as to the estate. So there's flexibility there. The alleged incapacitated person also needs to be served that there's a guardianship petition that has been filed. Typically, it is done by the guardian ad litem when the guardian ad litem meets with the AIP, which is a requirement that occurs a little later on. The guardian ad litem also has to serve within, or has to file with the court within 5 days of being appointed, needs to file their statement of qualifications. In King County, the guardians ad litem are chosen by the court off of a registry of people who have already qualified. So this is not quite so much an issue in King County as it is in other counties where they don't have a pool of necessarily qualified people to serve in this role. This additional task at row 8 is just simply to allow efficiency in service between the parties, the attorney for the petitioner and the guardian ad litem. Again, now regulated primarily by court rules that make this automatic. The guardian ad litem is supposed to meet with the AIP as soon as possible, but we've put in here that that would occur within a week of appointment, and that would be rather ordinary and typical. When the guardian ad litem meets with the AIP, they advise the AIP of the guardianship and the petition and review it. They ask the AIP, do you want to have an attorney? And if the AIP says, yes, I do, then they need to advise the court. And this is C7, so we'll go back up here. Here's cell C7. It says that's going to happen on July 28th. Then by 5 days later, and again, this is typically going to be court days, so it might include the weekend. So these are approximate dates and would have to be re-examined as the actual dates occur. Make sure that the due dates are filled in, but that would need to occur by August 2nd or perhaps August 4th if there's a weekend, or even August 5th if there was a 3-day weekend that was thrown in there for holidays. The court then needs to appoint that attorney, if there's going to be one appointed, at least 3 weeks before the hearing on the petition for the guardianship, so that the attorney for the AIP has some time to prepare for that hearing. In this case, we're looking at cell C15, and it's at least 21 days prior. We've calculated that from cell C17, and so that should be modified, but let's take a look at C17. C17 is the date of the hearing, which we expect will occur on its due date, which has to be 60 days, no more than 60 days after the petition has been filed, 2 months. So if it's September 19th is when the hearing is going to take place, then the court has to appoint the attorney for the AIP on August 29th. Most guardianships, the AIP cannot communicate, and the guardian ad litem must determine whether they need an attorney to represent them, and if they're that badly off, then they typically will recommend not, because it simply costs their estate more money and doesn't really add to them and provides really no protection for their individuality or their individual rights. It's only in close cases that a guardian ad litem would recommend the appointment of an attorney for a person who's saying, hey, I'm really not incapacitated, I want to fight this thing. The guardian ad litem also has to arrange for a medical or psychological report, and that must occur at least 15 days prior to the date for the hearing. After that, the guardian ad litem must work to locate and interview and talk with appropriate people who have knowledge about the AIP, relatives, friends, any caseworkers or social workers that have worked with the AIP, or support providers, and also the proposed guardian to assess. And maybe there's 1 or 2 or 3 that are saying, hey, I'd like to be the guardian. Typically it's just 1, but the guardian ad litem would assess that person. Ultimately, the guardian ad litem has to submit a report to the court with recommendations, and that's 45 days after the petition or after their appointment, and at least 15 days prior to the hearing. If the hearing is going to be continued, that also needs to be served on the AIP and the guardian ad litem, and sometimes things need to be pushed back because there's still work to be done. The notice of hearing needs to be served, and that's at least 10 days, and if you're going to mail it, it has to be plus 5 days for mailing prior to the hearing date. And all of these C15s really should be C17, because that's the date that we're really hinging all of these from. This date here is based on the date of the petition filing plus 60 days. After the hearing, and assuming that the guardianship is established, there will be a permanent guardian appointed, and the guardian ad litem will be done with their work and will be discharged. The permanent guardian then takes over the case and must, within 90 days of the date of the hearing on the guardianship, come back to court and say, here's the inventory of the financial estate of the AIP, and here's a personal care plan. They need to be in a nursing home. They need this level of care. This is the kind of cost it's going to take. This is where they're going to live. These are their needs. And that would then be within 3 months. So it's 2 months to get to the guardianship hearing, typically, and 3 months to get to a point of having a report that the court approves for the care and financial well-being of the AIP. Thereafter, there's usually annual reporting. It can be triannual, but this spreadsheet is basically to outline the 2 months that takes place for the establishment of a guardianship under Title 11.88. I hope this has been helpful to you, and if you have any questions, please feel free to contact us 206-327-9335, and we'll be happy to answer your question. Thank you.